Yeah, we can talk.
Yeah, come on up to the podium.
We can talk, man.
Hey, keep going.
Yeah, please.
Yeah.
Two case files, 24-02561 and
93 days, right? Is that what you recommend?
Yeah.
That's what you recommend, but you were cool with it. You said no probation. And hey, Andrew. Hey, Andrew. No, Andrew.
How this works.
If not everybody's in the same socioeconomic class as you are. And it was $400 for the tether just to buy it, and it was $300 for a month just to get it.
The last thing I want to do is put you in jail because you're causing an upset to the court.
I agree. I agree with that. What up, man?
I need you to relax. Otherwise,
I'm cool,
You're
man.
here to review. The
I'm
idea
here to
here is to
review.
get you guys, Mr. Finley, Mr. Finley, you have to stop. You have to stop. It's a review to get you back on the right track.
Right, but here's another thing, and
Yeah.
here's another thing, and when we need people to, you gave me time, that would be like giving someone time for a parking violation. It don't make sense, Andrew, you smart, man.
That's not how this works. I'm gonna give you
How
a
that-
chance to relax.
Just stand here and let's do the review.
Mr. Young?
I'm still recording. And you can read it, all the statutes you want. If it doesn't make sense, it doesn't make sense, Andrew.
Mr. Finley, I have to hold you in direct contempt for
Oh.
continuing to interrupt.
Let's go with
the court. You're sentenced to a day in jail.
Buckle up, guys. Today we're diving into a courtroom double feature where chaos meets justice. From a disrespectful defendant who just can't stop talking, to a self-proclaimed legal expert challenging the judge's patience. This one's going to be wild. 2 cases, 2 lessons, and a whole lot of courtroom heat. Let's get right into it.
Of Midland Credit Management versus Rachel Langone, 24-04774. Counsel appearance, please.
Yes, good morning, Your Honor. Elizabeth Smith, P63010, appearing on behalf of Midland.
Okay, and then I see the defendant and counter plaintiff. Please state your name for the record.
Rachel Langone.
Your volume is a little low.
Okay. Is that any better?
That's better. Okay, so today was the date that was scheduled for a motion for summary disposition that was filed by Midland. Let's see. And let's see. They're asking for the court to strike, excuse me, the defendant's answer and dismiss the counterclaim, saying that the counterclaim doesn't seek relief that the court could grant. I'll let you make your motion on the record, Ms. Smith.
Thank you, Your Honor. To address the counterclaim first, I'm sure the court has had opportunity to review the counterclaim. It's a two-line counterclaim saying that she is seeking dismissal of the claims against her and asking for an award of $3,744. It does not go into any detail about anything my client would have done wrong. So there's really no basis on which to grant any sort of relief as to the counterclaim. As for our motion for summary disposition, reviewing the defendant's pleadings filed, the crux of the matter is she doesn't believe that she owes anything to Midland because the original creditor was a different entity. So it was a Children's Place credit card held through Community Bank. The account was used. We attached about a year and a half worth of billing statements to our motion showing use, purchases and payments on the subject account. In December of 2021, the account was charged off and sold to Midland. Also, as part of our documents is a letter sent by Comenity to Ms. Langoni explaining that the account with Comenity has been charged off. It was purchased by Midland Credit Management. Any further communications and or payments were to be made with Midland Credit Management. Ms. Langoni did in fact contact Midland and set up a payment plan. The payment plan was ultimately defaulted with only 1 or 2 payments having been applied to the account. So there's just really no issue left to resolve. Midland owns the account. The balance due and owing, there's no dispute as to that. There's no dispute that Ms. Langoni had the original card. The only issue is her belief that she doesn't have to pay Midland. And again, based on the proofs provided by Midland, and the fact that there was in fact a payment plan set up with Midland, I'll point to the fact that Midland does in fact own the account, is permitted to collect on same. And so we're asking that Your Honor, please dismiss the counterclaim for the reasons previously stated, and then also grant summary disposition on Midland's claim, as there really is.
All right, guys. Here's where the tension kicks in. The defendant refuses to follow simple courtroom protocol, cutting off the judge, mumbling under his breath, and testing every ounce of authority in the room. You can almost feel the judge's patience fading as the exchange turns sharp and confrontational. The calm before the inevitable storm.
I don't see a response to the plaintiff counter defendant's motion from you.
No, and I did try to contact legal aid and get some advice. The only thing that she told me that I could do was to ask you to amend my response. As far as what she sent, I still, when we were here the last time and I met with counsel in a separate room, I still maintain that I would like to see the contract. Whether that's, especially between myself and Comenity, to see that they were legally able to sell the debt. Because if I could go to trial, I would show that the chances that the Comenity was paid for the debt. And I want to be able to show that. It's very different, because if I were to go to court with Comenity, that would have to go through a federal court. It's very different. Let me
get some clarity here. You're not disputing that you had a Children's Place account, correct?
Correct.
You're not disputing that there was a balance of $643.63?
No, I'm not disputing that.
Okay, your dispute is that you have paid that $643.63? It
was paid when I opened the account.
It was paid by who?
The process, and this is why I wanted to.
Here it is, the breaking point. After several warnings ignored, the judge has had enough. In a firm, no-nonsense tone, he declares the defendant in direct contempt and sentences him to a day in jail. You can sense a shift in the room, from arrogance to shock, as reality finally hits. The authority of the courtroom is fully restored in a matter of seconds.
Your Honor, if I may, I believe this is, we've seen this going around online. It basically comes down to an argument that credit cards aren't real money, and somehow by opening a credit card, Comenity is really doing some other sort of banking thing, and it's not really money that has to be paid back. You have to let her give her response, because she's not actually drafted a motion or responsive motion to you. And then I'll let you respond to what she's saying, but she's got to have an opportunity to make her statements as to what she believes her defense is. Sure.
So you're saying you didn't pay, you charged $643.63 on the Children's Place card, but you didn't pay for it?
I did pay on it at the time because I didn't realize what had happened. And when this all started, when I started questioning what was going on, I had called Comenity.
What do you mean what was going on? I don't know what that means.
When I was trying to understand the legalities of a contract and how the banking system works, I was just studying this on my own. And so I had called Comenity a couple times, spoke to 2 different people, and all I did was I wanted the original contract so that I could learn the legal terms, how it works, the process. And when they kept telling me
Okay.
that they didn't have this contract, that's when I started asking more questions and learning that how important contract law is, and the fact that it's somehow magically disappeared. I don't understand why the most important legally binding contract would have just magically disappeared. So I started asking a lot of questions, and what I'm basing it off of is off of federal regulations, federal codes, the UCC 3. It's not what the attorney just made it out to be, but it is a lot to explain, and I'm still learning. But
Okay.
I do want to maintain.
With the summary disposition, you don't just get to skip over that portion. If there is a motion for summary disposition, they're saying that you don't have a valid defense, that you have not presented an issue of genuine dispute. You need to now plead to me something that makes me believe that there is an issue of genuine fact that needs to be resolved by either a jury or a trier of fact. And you've not yet provided me that. That's why it was important for you to respond in writing to their motion. I'm giving you an opportunity now to respond verbally, but I need to hear some information that would allow me to understand your mindset and why you believe that you can open a credit card and then charge a balance and then not have to pay the balance.
Right, and that's
So answer that.
it is very difficult to explain, but I 100% would not have disputed this with Midland if that was the case, that I just wanted to borrow money and not pay it back. That's honestly,
Okay, so
that's not what it's about.
I don't mean to cut you off, but I'm trying to follow. So your dispute is that the past due debt was charged off? I'm not following what the dispute is.
My main, I feel like I need to, I'm obviously, I didn't go to law school, so understanding this process is not easy for me. And if I lose the case, it's going to be because of a procedural issue and my own fault, not because I'm wrong, though. I've learned way too much about the bank's process.
Now the stage resets, and the next act begins. A woman steps up, confident but clearly misguided, ready to take on the system by herself. The judge introduces her case against Midland Credit, and right away, her misunderstanding of the law starts to show. It's calm, it's polite, but you can feel confusion brewing underneath every word she says.
That there's no contract.
I would disagree with that because what you've said so far was that you opened a credit card, that you used that credit card to purchase some things, and then you didn't pay the credit card. And I'm trying to understand, but you said that the credit card, it was paid, and I'm trying to figure out how was it paid if you didn't pay it?
It's the banking process when I provide my social security number and did not fully understand what I was signing and what I was signing over.
Okay, so because you signed a contract for a credit card and you didn't fully understand, you think that that's a defense?
Well, see, that's the tricky thing is my defense would be different with Comenity versus Midland. So anytime
we're not talking about that. We're not talking about what hypothetically your defense would be with Comenity. This is Midland Credit Management versus Rachel Lamco.
So I'm maintaining that they don't have there's no contract to base any of the allegations in the papers that Midland has submitted. It's all based off of if there was a contract, and there is no contract.
There's no contract, you mean, between you and Midland Credit Union? Is that what you're saying?
Or
credit management?
Or myself in Comenity. Nobody has that contract.
No, I didn't ask you if anyone had the contract or anyone's produced it. I've already stated on the record that you signed a agreement with Comenity.
Right, but usually there's clauses in that agreement if they can legally sell my debt to a third party. So I would like to see that they could legally sell my debt to the third party.
Okay, so your defense was that you wanted to see evidence that they could legally sell the debt to Midland.
Yes.
Okay. Any other defenses?
No. Thank you.
Okay, and then you filed a counter suit.
Yeah, that was for my time doing
For
it.
your time?
Yeah,
What do you mean for your time?
for responding and getting this suit that I don't agree with, and I figured if the attorney would get paid for their time, then I could get paid for mine.
Do you believe that you should get paid $3,744 for your time?
Things take a turn as she launches into her argument, claiming the debt isn't real, the contract never existed, and the entire financial system is somehow flawed. The courtroom atmosphere thickens with disbelief. The judge listens carefully, try and make sense of her scattered reasoning, while the tension between legal logic and conspiracy grows with every sentence.
The claim is dismissed. It's not properly pled. You've not provided any basis upon which the court can grant you $3,744 for responding to a lawsuit, which I'm going to cut to the chase. It's very clear to me that you have opened up a credit card and you failed to pay the debt. Now, whether or not committee had the right to sell or transfer your debt to another entity, which is common in when you open up a credit card, that's unknown. Did you provide that information for her, Ms. Smith? We can't hear you. You might be muted.
Sorry, I did mute myself because I had to cough. I don't believe so, other than the letter sent by Comenity to her indicating that the account had been sold and Midland now owns it and was able to exercise full rights to collect.
This is where the judge steps in, dissecting her points one by one. He remains calm but direct, exposing holes in her logic and asking questions she can't quite answer. You can see the shift from confidence to hesitation as the judge forces her to confront the real facts. It's a masterclass in composure and legal precision, logic overpowering delusion in real time.
On it. That was sent to her back in December, of 2021. And that was included as part of the documents attached to our motion. And then again, I would also emphasize that there was a payment plan made with Midland as well, so.
She made a payment plan with Midland?
Yes, there were two $15 payments made to the account.
When?
This was, give me a moment, Your Honor, it's in the motion. They were made, there was one payment for $15 made August 28th of 2022. That payment was actually returned on August 31st of 2022. And then there was another $15 payment was made October 27th of 22.
Why was the August 22 payment returned?
My system says declined. I'm not sure if, that could be, like if a credit or debit card was used and then it ended up being, like an invalid account number, or like the account got closed, or it could be an NSF.
Okay, but the October 27, 2022 payment was accepted?
That's correct, Your Honor.
Okay, so Ms. Lancone, you've actually waived any defense or argument that you had that you didn't have a debt or a duty to pay the debt. You tried to make payment.
The tension peaks as she doubles down, insisting there's no valid contract and refusing to back down. Her voice carries defiance, but her argument is collapsing fast. The judge gives her every opportunity to clarify, yet the reasoning stays circular. This is her last stand, a futile attempt to hold ground while the courtroom watches logic dismantle her case completely.
You've waived that argument. Even if they were to provide you a physical copy of the agreement, which I don't know how you applied for this credit card. I don't know if you applied in a store. I don't know if you applied online. You're not disputing that you applied. You're just disputing that there may possibly have been a clause in there that would be a defense for you. But you have not been able to produce any of that on your own. You've produced nothing to the court. To the contrary, you've produced information through your answer and even in your responses today that tend to lead to the fact that you owe this money. You have no plausible defense to the debt. I'm finding judgment in favor of the plaintiff in the amount of $643.63.
Thank you, Your Honor.
Did you provide an order?
Certainly, we'll get that e-filed today, Your Honor.
Oh, okay. Thank you. You're all set for today.
Thank you.
Thank you.
And here's the moment of truth. The judge delivers a calm yet decisive verdict, breaking down every flawed claim she made. He explains how her own actions voided her defenses and dismisses her counterclaim without hesitation. Justice is served, not with anger, but with clarity. And that's how courtroom authority restores order. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next one.